And then there's this great guy, Lieutenant Governor Snyder. His editorial comment says, I am in favor of a proposition which will say that every white man in the state shall vote just because he is white, and no Negro shall vote just because he is black. Of course, we cannot put that into words, but certainly we can work to attain those results. The aim, according to him, is disenfranchising 75% of the Negroes. Why not just disenfranchise all of them? He goes on to say, if we leave the right to suffrage to 10 or 20,000 Negroes in the state, those Negroes will hold the balance of power. And what could be worse? This is in the newspaper before the convention. So now we arrive at that convention, February 8, 1898. If you pretend for a moment that you're in that room with me, you will see in the balcony a sign saying reserved seating for women 50 feet above, which means women could be spectators, white women, but of course not have an active participation in this process. So this would have been a convention of a 94-day convention of all white males. Now remember, this is post-Civil War, so there's some issues that are serious to the future of Louisiana. So these are the three issues that they're attacking at this convention. Suffrage, the right to vote, because we now have to give it to black folks. That was a new conversation. Education, because now we have to educate them. These are new things for the state of Louisiana. And then criminal justice, thanks to the great work of Major Samuel James. He kept that conversation very, very vibrant in order to fuel his very lucrative convict leasing enterprise. So I want to read just one quote about what they said concerning their education discussion. Very important you hear their words and not mine. The most revolting scheme of the federal government, the most irritating and dangerous, was the proposition for mixed schools, the co-education of races, the late masters and the late slaves, Caucasians and Africans in the same schools, with the same teachers, a proposition that is so alarming and so pregnant with untold evil. This is the views on education. The next thing that happens is there was a discussion about lynching legislation, and they responded by saying it's not significant enough for us to address it at this moment. So they indefinitely postponed that. Of course, the poll tax was adopted at this particular convention, and then someone said that there were a number of heroic figures in the state, i.e. those Confederate people who fought to maintain a system of slavery, and those Louisiana legends should be compensated. This convention agreed and offered them an actual pension that came out of this convention. And then we get to Article 116, which is where Louisiana's non-unanimous jury law was formally adopted into the Constitution. And at that time, the system required a vote of 9 of 12. Remember, I said to you currently, we are requiring 10 of 12. So at the end of that 94-day convention, the delegates reflected about the work they had done on these very significant issues. And I want to end that convention talk with 2 of those reflective quotes. One, again, is from Mr. Thomas Sims, who is not a small figure. This is a man who was the actual chairman of the entire Judiciary Committee. And I want you to hear his words because they don't lend themselves well to interpretation. But Mr. Sims says, the work we have done should be crowned as worthy. I have no apologies to make, no regrets, nothing to change or recall. In all states, those in power seek to maintain it. Our mission was to establish the supremacy of the white race in the state to the extent to which it could be legally and constitutionally done. Final quote comes from the president of the convention himself, who had already gone on record in the editorials, Mr. Krusenig. I say to you that we can appeal to the conscience of the nation, both judicial and legislative, and I don't believe they will take responsibility for striking down the system that we had reared in order to protect the purity of the ballot box and to perpetuate the supremacy of the Anglo-Saxon race in Louisiana. Not my words. So what were the intended consequences? One, to maintain that caste system that we talked about. Two, to further the capitalist agenda that we talked about. And three, jury discrimination. How were they going to do it? Through fast convictions and through black jurors sitting on juries without the authority to block convictions. What did they use to figure out this magic number 9? They used voter registration records. They looked at the voting registration records and say, how many do we need to eliminate to dilute their voices? So this was not done without planning and thought and very mischievous intentions involved that we get this law. So the law is formally adopted in 1898. We will fast forward to the 1970s. There are two important events to come out of the 70s. The first one is the 1972 Apodaca ruling that I mentioned to you earlier. It's still deemed a precedent. Apodaca does not involve Louisiana's law, but Louisiana courts have repeatedly held it a precedent. What Apodaca does do is raise the question of if Oregon's non-unanimous jury law violates the 6th and the 14th Amendment. Now, this opinion is very troubling for a few reasons, one of which is the lack of sound reasoning. Because what the United States Supreme Court did is says, well, we don't really know what the numbers mean. We can't tell you if it matters if you get 10, 11, or 12. But what we can tell you is that we think, conjecture, that a real trial and a real deliberation simply means that there is human interplay in that deliberation room. That's the extent of which they reasoned. Now, the second reason I'm critical of this opinion is that it's a very weak authority because it was a plurality decision, meaning there was no full majority vote. There's 3 and 3 and then a split vote. So those are two troubling things about Apodaca. But there's something good that came from Apodaca, and that is that Apodaca inspired over 45 years of very credible research. And I don't mean research by lawyers that went looking for experts. I mean research by psychiatrists and psychologists who have that passion to study this thing called group thinking. And that research is quite compelling. And in my opinion, it is the strongest reason for Louisiana to abandon its non-unanimous jury law. But in all of the discussions, it's the one that gets the least amount of attention. But what this research has taught us is that there are two deliberation styles. There is an evidence-driven deliberation style, and then there is a verdict-driven deliberation style. Under the verdict-driven style, the jurors will get in the jury room and they will just ask immediately, does anybody have a verdict in mind? And if 10 hands go up or 11 hands go up, it's over. Why? Because there is no motivation for you to entertain the 1 or 2 people because we already have what the law requires us to have. The second evidence deliberation style is the evidence style. And under that model, what you will see is a lot more participation from all jurors, even if we don't agree, by the way, but they would have a chance, of course, to invite their input into the discussion. What we now know from those researchers is that a unanimous jury is more reliable, it is more careful, it is more thorough, and it does ensure the full participation of all of those 12 jurors. So minus that change that we saw from 9 of 12 to 10 of 12, there's nothing else happening with this law in 1973, nothing else. So those are the two major things that happened in 73. And what I would like to do now is move on to some of the unintended consequences that are affecting people now of all races. And this has been, from the last 4 years of research, I've developed much of this. The first one comes from the Innocence Project, who's been very, very gracious about sharing their research. And what they've been able to tell me is that we have a high exoneration rate in the state, which means we have a high rate of wrongful convictions. But the Innocence Project actually says as of 2017, there were 14 exonerations and 11 were the result of non-unanimous juries. That's pretty compelling. The second thing that I have learned from this research is that defendants in Louisiana and their lawyers are so afraid of Louisiana's non-unanimous jury system that oftentimes people would prefer to take a plea bargain than to take the gamble of going for a jury trial. So what this system does is incentivizes people to take a plea. So now I just want to pause and make sure you hear me, because if it's causing wrongful convictions and it's incentivizing people to take a plea, we just solve the big mystery of how we got to be the mass incarceration capital. We just figured it out. This one law has done that kind of damage to an entire state. The next thing we know is that this creates a voting rights issue, and this is not intended. Now, let me be clear. What was intended was that Black folks couldn't vote. What was never intended was that we would have a system of mass incarceration that criminalizes everybody, all colors. And under Louisiana's law, once you are convicted of a felony, and I want to be very clear about this, the law says if you are under an order of imprisonment, which means you don't have to be in physical custody. You can be on probation and parole, and you cannot vote. Now, we do have some positive traction on this law, but it will not take effect until March of 2019. So it will not benefit us in the upcoming election. And the new change will simply add that if you haven't been incarcerated in 5 years, you can in fact exercise the right to vote. The other unintended consequence of this system is that it marginalizes women and minorities. Please note that I didn't say Black women and Black folks. This is all women and all minorities. And the best evidence of that came from the Advocate's incredible Tilting the Scale series. So if you haven't read it, you need to read it. And I also want to mention that the night we convened the very first strategy session in this room, October of 2016, is where this campaign was first revealed to the public. The Advocate was in this audience, and that is what caused that series to result. And I want to make sure that we recognize that Southern has played an instrumental role in this battle to dismantle this system from the time that the first forum convened in October of 2016. So that Tilting the Scales data shows us that women are being called at lesser rates for jury service. Minorities are being called at lesser rates. So if you have less folks showing up and you can silence a few, you have now marginalized a few more voices. Another unintended consequence. And here's a fascinating one. In 1986, the Supreme Court of the United States handed down a ruling called Batson. And Batson says you can't stop a person from serving on a jury because of race. Now, guess what Louisiana's non-unanimous jury law does? It allows Louisiana prosecutors to circumvent Batson. Why? Because we will seat you because the Supreme Court says we have to. But once you're seated, your voice does no good because we can ignore you on the back end by way of this 10-2 or 11-1 vote. That is another piece of this that has been underreported. And finally, another unintended consequence. Way back in 73, when this law was changed, Louisiana treated all murders equally. There were no degrees of murder. So that meant if you were a murder case way back, you automatically got a unanimous jury. That is not the case anymore. Oregon has been very careful to protect people accused of first-degree murder. So when you read Oregon's law, it specifically says if you are a first-degree murder defendant, you cannot be tried by a non-unanimous jury. There is no such protection in Louisiana's law for first-degree murder. So what that means, if you understand Louisiana's law, is that we are sending people to mandatory life sentences, hard labor on the plantation of Angola without the protection of the full assent of 12. Now, what's troubling to me about that is that Louisiana's legislature saw fit to say, if we're going to take your life by way of execution, you need 12. But if we're going to take your life, not in a literal sense, but in a non-literal sense, your life doesn't matter as much. I think that was also an unintended consequence. So on the 6th of November, you will see Amendment 2 on the ballot. I want to read you the ballot language so you are familiar with what will appear. Amendment 2 will say, do you support an amendment to require a unanimous jury verdict in all non-capital felony offenses that are committed on or after January the 1st of 2019? That is the language that will appear. I have no desire to suggest to you how you should vote, but I do have a desire to be sure that you are informed and educated when you cast this historic vote. So I have been asked to maybe explain to you some of my concerns, one of which is the public safety nature of this. Because if we are moving fast in those deliberations and we are convicting the wrong people and we are making people plead to things that they don't deserve, that means the real people are still amongst us. This is a public safety concern at this moment. And that is my first and foremost concern about the upcoming vote. Secondly, I remind you about the intentions behind the Sixth Amendment and the way the word accused appears in the amendment. That is because it does not apply to criminals. It applies to innocent people. And because liberty is sacred to me, I don't want anybody's life taken without the full assent of 12 jurors. And why would it matter to us? Because we have a past violating people's liberty protections, taking people's bodies when they should have never been held in captivity. So if it doesn't matter to anybody else, it should certainly matter to all of us in Louisiana. My other concern is the economic impact of having such a law, because now that this is a national conversation, I'm left to wonder, what business would really want to relocate to a place that has Jim Crow laws on the books, a place where its workforce couldn't be properly protected with all of the Sixth Amendment guarantees that they would get in any other state? I also think we need to really honestly embrace the fact we have not healed from all the years of slavery and lynching and domestic terrorism that has happened in this country. We've never healed from that, and this presents a wonderful opportunity for us to do it. The other consideration is this. When Oregon changed its law in 1934 and went from a unanimous to a non-unanimous system, Oregon actually put it in their voting packet, telling their voters, we are doing this because we don't like outsiders. Oregon was the only state admitted to the Union with an exclusionary clause. Black folks, you can't come here. That's what I mean by exclusionary. Oregon told its voters why they were doing this. We never got notice in 1898. This was not the will of the people. In 1973, when this came back up, we never got a disclosure in our voting packet. And so this is the first moment in the history of this law where we are now informed and able to cast a vote. So this is our time to show the world who we are in Louisiana, and that's why this vote is so significant. So as I close, I hope you agree that we have thoroughly deconstructed this narrative. And I hope you realize the counter-narrative teaches us some very important lessons. The first of which is voter suppression is not a new tactic. It has been an effort since the 1800s. The second is that challenges to Louisiana's non-unanimous jury system, they're not new either. Mr. Martinet launched one in 1898. We sat in this room and talked about the years that defense lawyers in Louisiana have filed motions and objections. This has not been discussed in court. We talked about lawyers having filed certs up to the Supreme Court. There's a man in New Orleans, Ben Cohen, said, I'm gonna file a cert every time I get one, and I'm not gonna stop. Nobody knows that he's been doing that over the years, so certainly this is not new. What is new is the legislative strategy. And I'm gonna tell you how that happened and why it was so important. Because after I had researched and realized that this history needed to be exposed and that lawyers were trying to expose it to the extent they could in the courtrooms, courts were not going to entertain this. And I am a civil rights lover, I'm a history lover, and it occurred to me one day when those folks in Money, Mississippi did what they did to Emmett Till, we wouldn't have had a movement if Mamie Till would have kept that casket closed. But it was her desire to expose that launched the movement. And so that was my thinking when I wrote that first article in 2015. We're not gonna do this no more politely. We're not gonna file no more motions. We're not gonna file any more certs. You're not gonna do this on our watch. And I'm gonna tell you right now, this movement has been ordained. It has come at great personal sacrifice to me and all the other ones of us that have traveled the state fighting over this. But I remember sitting in this law center being told that there was a mission here. And that when you come to Southern and you get a degree, it is not about you ending up in a certain zip code. It's about you advancing society and making changes. And that's why this commitment was made, and that's why it has continued, because there are people behind the scenes that have fought quietly. You don't know who they are, but they have been fighting behind the scenes. I was in my office one day and the chancellor said, come here. And you know what that feels like, right? But it was to let me know the American Bar Association had read something I wrote in the Washington Post. And they wanted to see if I would be willing to help the bar draft a change in policy, which I did. Nobody knows. Nobody knows. But as a result of the articles and the scholarship and the research, there has been a change at the bar level. the body that regulates the whole practice of law, specifically telling Louisiana and Oregon this has to stop. So I just want to encourage you all to opportunity to have a law degree. It is not about you. It is not about you. It is not where you live. It is not what you drive. It is about how relevant your walk has been. Whose lives have you changed? What improvements have you made? And for all of those students, including mine, that want to have drama when they're told to read a case, I just want to tell y'all I've been reading cases for 4 years, and I got a law degree. That's what this requires. You got to be willing to work, and you got to be willing to understand that for me to be good, I have to work on it. And for all the people that have fought with me on this, many of these lawyers, Marjorie Esmond, Richard Bork, I can't stop naming names. All of these people are older than me, practice law longer than me. I can't go booting up to them people acting like I know everything. You got to learn sometimes when to role play. I'm a student sometimes as much as I'm a professor, as much as I'm an advocate, and that's my other messaging. Next lesson I hope you have learned from this counter narrative is that racism, oppression, and discrimination can be sustained by systems. Sometimes we look at individuals and think they are the actors, but oftentimes it is a system. Next lesson, the counter-narrative teaches us that emancipation, it was never about physical freedom, and if you think that, please be corrected. The civil rights movement was never about physical presence, and if you think that, please be corrected. The struggle was always about social, legal, and political equality, and we have not gotten there yet. Last point, I hope you learn from this counter-narrative that this particular piece of legislation will be the most important criminal justice reform we will see in our lifetimes, just because of the volume of people that are adversely impacted by this system. So I'm going to end by telling you that if you understand this counter-narrative, then you know now that you must leave here and reclaim your power. We must all leave here and tell everyone we know that on November the 6th, we will evict Jim Crow from the state of Louisiana. I thank you so much for allowing me this opportunity, and I'll be around if anybody has questions, because I think I have exceeded my time. All right. Thank you. I also want to say this one thing. Now, isn't this awful? I was coming down and my parents were in the lobby. So this is what it takes for me to see them because of all the non-unanimous jury work. I don't visit. They have to come see me. But they're on the front row along with my uncle and my cousin, all the way from New Orleans to be here with us. Thank you all. Okay.
Everyone join us outside for a rally thereafter. I know you guys all have questions for Professor Bell. We have a rally directly after. You hear from Representative C. Denise Marcel, Congressman Cleo Fields, and others. This lady, Professor Andrew.
I think we're gonna make your mom and dad very, very. You made me almost cry. You don't need the prep. God is with you. I'm taking the message to be out here this morning.
What, Dan?